Okay, sige. So, kana, maklaro?
Yes, sir.
All right, so let's start.
Yes,
Let's
sir.
start. All right, so you are now enrolled in Criminal Law Book 1. So this is a course syllabus intended for criminology students, wherein you'll be able to learn a lot of concepts regarding criminal law. So you already know me. I did not introduce myself. So I hope you'll be able to learn a lot from today's lecture. So I have several references from Criminal Book 1. Among these books include the books of Attorney Gabao and Senior State Prosecutor Buado, Judge Campanilla, and the very famous Criminal Law book of Justice Reyes. Apart from those books, I also use the Revised Penal Code, which is Republic Act 3815, which is amended by Republic Act 10951, an act which amends certain provisions of the Revised Penal Code, particularly the penalties. So if you want to study Criminal Law Book 1, you have to have the Revised Penal Code and Republic Act 10951. Okay? All right, preliminaries. So your Revised Penal Code of the Philippines is also known as Republic Act 3815. It is called an act revising the penal code of the other penal laws. So, preliminary article, which is Article 1, this law shall be known as the Revised Penal Code or the Book 1. So your coverage for Criminal Law 1 are the following. So you have Articles 1 to 113. Medyo daghan-daghan din siya na memorize ninyo. Article 1 and 2, preliminary 3 to 15, felonies and circumstances which affect criminal liability 16 to 20, who are persons who are criminally liable 21 to 88, the penalties 89 to 99, extinction of criminal liability, and lastly your civil liability. Because for every criminal action, there is always a civil action attached to it. Now, your Article 1 of the Revised Penal Code states that when does this take effect? So the code or your RPC shall take effect on the first day of January 1932. In short, your Revised Penal Code has been in effect since January 1, 1932. My God, siguro mga lolo-lola pa na ito ang buhay pa na. Alright, so this is the most common question in your board exam. What is the definition of criminal law? So according to numerous sources, criminal law is that branch of law which defines crimes, treats of their nature, and provides for their punishment. So again, defines crimes, treats of their nature, and provides for their punishment. So how does criminal law define, treat, and provide for the punishment? So an example of that is your Article 313 or altering boundaries or landmarks. Kung sa maling altering boundaries or landmarks, sir, your altering boundaries or landmarks, kung ginapag-awayan kung sa itong mga baryo, kanang imong gi-move ang muhon, kanang inyong monument, di ba mag-away-away man sa barangay, kaya gi-move nimo ang muhon nako kay para mo dako imuhang land area. So under the Revised Penal Code, that is considered as altering boundaries or landmarks and punishable under the Revised Penal Code. So according to Article 313, any person who shall alter the boundary marks or monuments kanimong muhon of towns, provinces, or estates, or any other marks intended to designate the boundaries of the same shall be punished by arresto menor or a fine of not exceeding 20,000 pesos or both. So sir, asa man diha ang definition sa altering boundaries. So this is how criminal law.
Ayoko mag-charger na po.
Kindly turn off your microphone. Kindly mute your microphone. All right. So how does this?
Pa-charger mo.
Right. So how does criminal law define altering boundaries? So it defines the crime of altering boundaries as any person who shall alter, meaning isang tao na mag-uhon ang boundary or mark sa muhon. So that is how it is defined, the altering boundaries or landmarks. How about traits of their nature? When you say traits of their nature, it is dependent on what type of nature this crime belongs. Like for example, since it is punished by arresto menor, meaning it is a light felony only. Or for example, imo yung gi-move ang mohon from one place to another. So that means you have consummated that crime, meaning all of the elements of the crime are present. Imo yung gibuhat from one location of the mohon, gi-move to another. So that is consummated. So that is how the law treats the nature of the crime. And lastly, it provides for the penalty. So since the revised penal code provides the penalty of altering boundaries, it provides there you will be punished by arresto menor or a fine not exceeding 20,000 pesos or both. Now, criminal law, diba, defines crimes, treats of their nature, and provides for their penalty. What if there is no crime that provides for that certain act? So you have there the Latin maxim, nullum crimen nulla pena sine lege, which means there is no crime when there is no law punishing an act or omission as a crime. So it tells us that what is punishable and what is not punishable. So for example, you did an act and you found out in the revised penal code that it is punishable. Then it is punishable because the law so provides. However, you did an act, but it is not covered under the revised penal code, nor any special law, nor any ordinance. Then you have no crime there because the Latin maxim is very clear: nullum crimen, nullo pena sine lege. Wala kay crime if walay balaod na nagapunishes sa imuhang gibuhat. The very most famous example of nullum crimen nulla pena sine lege happened in sometime in 2000, wherein the love bug virus was released to the whole world. Now, the love bug virus was created by a very genius Filipino. So what he did was he made a virus and he spread it throughout the World Wide Web. And because of the damages, that were attained, it reached, I think, mga around $10 billion ang damage na na-cause aning love bug virus. So the other countries who were affected by the love bug virus were mad at this certain Filipino for unleashing the said virus. They said that he should be incarcerated and he should stand for trial because of the crime he committed. But during that time, in 2000, there was no law that provides for the crime of cybercrime. As a matter of fact, cybercrime was only enacted and took effect in 2012. So since kaning love bug virus, kaning pag-unleash sa love bug virus, walay crime na nagapunish ani in 2000, that Filipino wizard, that Filipino genius guy was off the hook. So wala siya gipunish kay because Nulum crimen, nulla pena sine lege. There is no crime when there is no law punishing it. Claro.
Yes, sir.
Yes, sir.
Correct. Sige, ganun. So note, whenever a law provides for a punishment, it is a criminal law. So for example, kaning National Internal Revenue Code di mo, sa maning NIRC code, ano imong tax law? Do you think it's just a tax law which provides you, mo ni dapat imong tax, mo ni imong bayron kada yearly? Some people tend to, ano ba, like misunderstand it as a mere tax law, but as a matter of fact, it is also a criminal law because it provides penalties whenever you fail to pay your taxes. Like for example, evasion of tax or not paying the right amount of tax which is due from you. So your NIRC is also a criminal law because it provides punishment or penalties whenever you fail to pay your taxes. Next. Record mo tanong? Alright. Wait. Yeah. Okay, so may mga common forms of punishment spread across your revised penal code and other special penal laws. So you have your payment or fine, like for example, katong sa mohon, altering of boundaries and monuments, 20,000 pesos. It could be imprisonment. Imprisonment meaning jail time. Arresto menor means 1 to 30 days. So that's your imprisonment. And lastly, your death penalty, which is the capital punishment for heinous crimes or your grave crimes. Klaro ha, ang four common forms of punishment. All right, so what are your nomenclatures or terminologies to be used relative to crimes? So if the crime is punishable under the revised penal code, you call it a felony. So for example, Mr. Sumambot committed the crime of murder, si Bakupalayo. So he is considered, he committed a felony under the revised penal code. Okay, because murder is found under the revised penal code. Now, for example, si Miss, may mga naging tao dali. Si Mr. Eulosias Abusejo committed the crime of 1602 or illegal gambling. So that means he committed an offense punishable by a special law because PD 1602 is a special law which penalizes individuals who engage in illegal gambling. And lastly, you have your infraction or crimes punishable by city or municipal ordinance. Like for example, in Boston, if you fail to wear your mask by virtue of an ordinance, then it is as if you have committed an infraction for failure to wear the mask during COVID-19 pandemic. Klaro tang tanan.
Yes.
Klaro ang difference of felony, offense, and infraction na. Right.
Sorry sir, wala ko ka kuan. Nakapaminaw na ko atong gitawag ko nimo.
Ano naman?
Si ano mong good ko. Sorry.
Ano siya ka?
Oh, sorry sir.
Okay lang.
Pakibalik na lang sir, tapos sabto na ko imong pangutana kung okay lang.
Wala na nang ipagpuputan na. Igamit natin ka as example. Excuse me, okay? Allergies. Right. Let's move
Ay,
on.
sir, wait lang.
May pangutana na?
Sir, sa ganitong kwan, sir, katong kaso gani kung example, sa kataw, sir, kibaliban siya sa isa ka locality, sir. Sa ganitong kaso, Kung ang usa ka tawo sir sa kabuhat dili mayo sa isa ka locality, Davao. Kanang iban siya sir, di na pagtuon sa Davao pagbawal na siya sir.
Persona non grata.
Okay.
Meaning he is not welcome in your area. Persona non grata. But there is a penalty under the revised penal code which we call destiero, but this is only given to ating mga kabit gani. Usually ang punishment sa mga kabit kay destiero because kanang palayason sila ba, they should not be within 25 kilometers from the house of the complainant, or else 25 kilometers from the house of the complainant. Kay this is to protect the kabit kay basig dumugon siya sa mga relatives. So muna, just in case you're wondering. Okay, moving on. So sa imong sources of criminal law. So the criminal law is actually anchored on the Spanish Código Penal. It's in Latin. It is just translated into English via the revised penal code. So if we are looking for the exact terms of the terminologies, we should anchor or read more on the Spanish Código Penal. So you have other special penal laws like Commonwealth Acts, RAs or Republic Acts, Presidential Decrees, PDs, Executive Orders, or Batas Pambansa. Now, what are special penal laws? So if you can, I know you've already heard of Republic Act 9165 or your Anti-Drugs Law, Republic Act 9262 or your Violence Against Women and Child Act. These are considered as special penal laws because they are not found in your revised penal code. They are actually crafted by the Congress in order to meet the exigencies of time. Meaning, Congress will have to criminalize a certain act because of the need of the public. So your special penal laws are the result of the state's exercise of police power. Remember police power is lodged within Congress. So asa man yung Congress, sir? Kana House of Representatives and your Senate Committee. Kana silang duha, they are considered the legislative or your entire Congress. Now, kaning legislative department has the power or the police power to regulate and control activities or conduct which may be harmful or hazardous to the society and ensure public order, safety, and welfare of society. Now, previously, wala man yung Republic Act 9262. So there was a clamor among the public that lugi lagi ang babae, pero may malugi ang babae sa whether it be physical, emotional, or mental damage, di ba? Labi na pag ang imuhang relationship is abusive. So what the legislative department did was to enact Republic Act 9262 in order to protect the woman and her child. So mo na ang ihang exercise of police power in order to control, regulate, and protect the public from certain activities or conduct. Now, as a rule, any special penal laws are referred to as bala prohibita, meaning they are not really wrong, but by nature or for the purpose of achieving an orderly society, they have to be controlled or regulated. Now, an example of your mala prohibita is Republic Act 9287. Last two. Actually, wala may mali yun sa kanang maglista kag numero, tapos i-bet nimo siya para mudaog ka. Wala mang mali gid ana, wala mang morally wrong ana. But the problem is Congress saw it as kanang murag nagtinamad ang Filipino people ba nagsalig na lang sila sa last two aron modato ni sila instead of going out into the farmlands and till their land. Nagsalig na lang sila sa last two. So muna i-prohibit ang last two, okay? It drains the resources of the Filipino people. Kana imong kwarta mahurot dito sa pagpalasto or sa pagpa-gambling nimo, which is under PD 602 also. Now, not all special laws are mala prohibita. Some are mala in se. Like for example, the child abuse law, Kali Republic Act 7610. Morally wrong man yun ang mo sexually abuse sa bata, di ba? Or mo physically abuse sa bata. So it all depends on what crime is being punished by the special law. Usually it is the public who determines whether it is mala prohibita or mala in se. When you say mala in se, it is inherently evil. Mala in se or malum in se. Any questions so far?
No, sir.
Okay. Again, the power to define or criminalize and punish act as a crime is vested upon the legislative branch of the government. So your legislative branch comprises of your Senate and the House of Representatives. So si Senator Bongo, si Senator oh my God, I don't know my senators. Si Bato kana, one ang members mo sa Senate, whereas sa House of Representatives di mo kanang si a member of Congress ba? Tama ba? Kana, basta mga congressmen and congresswomen ni mo na members of House of Representatives din. But if you can remember, di ba, there are during the time of Marcos, the dictator, diffuse man gud niya ang unsa ang executive branch ug legislative branch. Mao na sa una nating mga balaod na presidential decree, Commonwealth Act or executive orders. Kaya tungkol na sa iyang binuhatan. Kag-diffuse niya ang executive branch o legislative branch, meaning siya ang himo sa balaod, siya po ang execute mo na siya'y presidential decree. Alright. Let's move on to characteristics of criminal law. So there are three. It has to be general, territorial, and prospective. So let's tackle each one exhaustively. So when you say generality, Philippine criminal laws are binding on all persons who live and sojourn in the Philippine territory. When you say sojourn, kanang temporary lang mga visitors, kanang mga tourists, kanang, di ba, unsa naman na sila, kanang short naman na ilang tenure dire, kaya bakasyon naman na sila. So that's what you call sojourn. So even though naa sila dire, Philippine criminal laws are binding on them. So if later on, while they are on vacation, these foreigners, they, let's say, nakakommit sila felony or infraction or offense, then mag-apply sila ang criminal law, Philippine criminal law. Generality also means that it governs all persons within the country, regardless of race, belief, sex, or creed. So maging sino ka man, it will apply, all criminal laws will apply to you. Now, what are the exceptions? Or kinsa man itong mga individuals who are exempt from criminal laws. So usually these are enumerated under international agreements or via public international law. The most famous individuals who are exempt from criminal laws are your heads of states, ambassadors, and other diplomatic officials. Another example is like, for example, kaning inyong legislative department, whenever they are in session and they are given the time to give their privileged speech. When you say privileged speech, they may say anything under the sun. Pwede sila mag-mock sa imo, pwede sila moingon na ikaw, official, corrupt ka, nangawat ka sa gobyerno, and they will not be liable for libel or oral defamation. More a few examples. Territoriality. So when you say territoriality, penal laws of the Philippines are enforceable only within the territory. So unsa may territory sa Philippines? So kaya Luzon, Visayas, Mindanao. But again, it is subject to certain exceptions by international agreements and practice. Meaning, pag may agreement, pwede po na ang penal laws nimo mag-apply outside of the territory of the Philippines. An example of that is your Article 2 of the Revised Penal Code, which we will tackle later on. Now, when you say territoriality, it comprises of 4 parts. So you have your body of land, meaning ka ng masses, kung asa ka indog karon mao na body of land, your airspace or your atmosphere. So from the ground and up, that is part of the territory of the Philippines. So let's say there in Katiil, kung asa mo naglingkod karon, from the ground and up to the airspace or atmosphere, that is part of the territory of the Philippines. What else? Interior waters. Diba sa Visayas, dagan kayo channel diha na waters because islands maguni sila. So this is what you call interior waters. So waters connecting the islands from one another. So these waters are also considered territory of the Philippines. And lastly, the Maritime Zone. The Maritime Zone extends 12 nautical miles or 22 kilometers from the outermost coastline. So for example, diya sa dagat ni Tatay, kanang outermost coastline diha. So kung mag-add ng 22 kilometers out into the sea, that is still part of the territory of the Philippines, which is also called the Maritime Zone. So to exemplify, kita mo anong puti na nag-surround sa Philippines?
Yes, sir.
Hello?
Yes,
Yes, sir.
sir.
That is your Philippine Territorial Sea. That is the 22 kilometers outwards from the nearest shoreline. So that is your Philippine Territorial Sea. And lastly, we have here prospectivity. So criminal laws are punished under the law in force at the time of their commission, meaning the law looks forward and not backwards, subject to exemption. So for example, di ba before, walay balaod na nag-punish og love bug virus kay wala may cybercrime law. So since by 2012, ligawas ang cybercrime law, so from 2012 onwards, considered as punishable na ang cybercrimes. Hindi na pwede na mag-look back. Hindi na ito pwede i-punish ng individual na nag-release sa love bug virus because as a because as a rule, characteristics sa imuhang criminal law is prospective, meaning it looks forward, it does not look backwards. Meaning, nag-move on siya, hindi siya nagatanaw sa likod. Ano kasi mong likod, magmahirap ka. But subject to exceptions.
Sir, excuse.
Yes,
Naanong ko ikuan, sir?
sure.
Kanang, di ba sir, naik ka ng law, sir, nga kintahay kay previous na ang nakomit nga crime. Di ba? Murag na siya, ano, sir, kanang 15 years nga. Unsa na siya, sir? Unsa na siya, sir, ma-apply?
Ha? Usa to? Yan daw? Hello? Nawala ka. Ano to, Pekano?
Koan, sir, kanang, di ba, sir, kay parehas ana, sir, nga situation nga na ay kanang year 2012 pa ni ang cybercrime nga law. Then di ba sir na ay ano kay kanang kung previous nimo na ano na ang crime na buhat tapos di ba murag na siya kuan sir kanang law nga murag 15 years after pwede pa ka mag-file ana nga case murag nakakuan na sir sa kanang sir sa kanang Rafi Tulfo. Pwede pa siya i-file ang case after basta dili siya basta dili siya malapas og 15 years.
Okay, you are talking about prescription of crimes. Ano when you say prescription of crimes, for example, ikaw, Perikano, gikulatan ni mo imong silingan, babae. Let's say that's slight physical injuries. So that means you are punishable by law, arresto menor or arresto mayor. So under the law, manggod, since it is a light felony, you have 2 months para i-report ang crime and mag-file of case. Or else, mawala na, extinguish na ang crime. So that means, within 2 months from the time na nag-commit ang crime, dapat maka-file na ka og case. Or else, dili na siya mo prosper ibuha ka. So kaya nag-prescribe na siya. Like for example, in other crimes, let's say,
Okay,
murder. Let's say nakapatay ka karon. Today is February 8, 2022. So if na mag-file of crime
Yes sir. Salamat sir.
Nag-yes mo? Okay, sige. Okay, let's move on. So may exceptions to prospectivity. Di ba as a rule, the criminal laws look forward and not backwards. But it may be given retroactive effect, meaning pwede siya mag-look back. Those persons covered under the old law provided the following are present. For example, if it is favorable to the offender. Second, the offender is not a habitual delinquent. And lastly, the new law provides retroactive application, meaning ang bagong balaod, nag-iingon mismo, pwede na siya mo apply retroactively. Now, ito may pasabot aning unfavorable to the offender. For example, ang crime na, let's say let's for academic purposes lang, let's say for example, na Republic Act 001, which penalizes individuals, let's say kung gisumbag nimo siya sa face. So let's say ang penalty ana is 10 years. Karon gi-prosecute siya under this law. So ongoing ang case. Now, while ongoing ang case, ligawas na pud ang Republic Act 002, which downgrades the penalty from 10 years to 5 years. So di ba favorable ang bagong balaod sa iyaha? So pwede mag-retroact sa iyahang kaso kay favorable man sa iya. So he may avail of the new law because the new law is favorable to him. Instead na 10 years ang penalty, 5 years na lang man. So that means favorable sa iya. And the new law may be given a retroactive effect. Klaro ba ang example sa favorable to the offender?
Yes, sir.
All right. Second, the offender is not a habitual delinquent. Now, under jurisprudence, habitual delinquent is a person who, within a period of 10 years from the date of his release or last conviction of the crime of robbery, theft, estafa, or falsification, is found guilty of any of the said crimes a third time or oftener. So, pasabot, let's say si Ekano na convict siya o robbery in 2010. Then in 2012, na-convict na po siya og estafa. Then pagka 2015, na-convict na po siya og pagawat, theft. kung naa may balaod na nag-aalaw og retroactive effect, dili siya maka-avail because she is considered a habitual delinquent. Why? Because in a period of 10 years from her last conviction, nakakommit siya og crime of robbery, theft, estafa, or falsification a third time or oftener. Mo na gitawag na habitual delinquent. And lastly, the law should provide retroactive application. Meaning, dapat sa balaod yun mismo, nakaingon dito, na kanina balaod, na magkikini ba ang balaod ng criminal law, nag-provide siya og retroactive application. Any questions so far?
Wala, sir.
Wala. Alright. Sure mo? Sure? Ilom na gining uman dali. Wait up. Wait lang. Hindi ako na yung nagkatok. Okay. Construction of penal laws. When you say construction, under the law, when you say construction, sabot are the interpretation. So how do you interpret penal laws? So if there is doubt as to the provision of your penal laws, the doubt is resolved in favor of the accused. So sa mga example, ano eh? For example, again ha, Republic Act 001 penalizes children 15 years, below 15 years. Kasi kanang balaod, Republic 001, walay criminal liability ang mga children 15 years below. Tapos, nakabutang po sa Republic Act 001 na nakay criminal liability if you are over 15 years old. Di ba medyo na ay doubt sa interpretation sa balaod kay kasi pasabot, let's say, na 15 years old. So asa siya mabilong? Sa below 15 years old or sa over 15 years old? Diba na ay doubt sa bagong balaod? So, kung na ay doubt gani, dapat i-construe or interpret mo siya na pabor sa akusado. So, dito ta magtanaw, so ako asa siya pabor. Diba if you are below 15 years old, you will not incur criminal liability pursuant to Republic Act 001. So since this is the one which is favorable to the accused, then kani ang dapat mo apply sa iya. Nakuha ninyo? Bug mo, no?
Sir, pwede balik, sir, ang explanation, sir.
Alright, sige. Let's say, for example, ha, Republic Act 001 is a criminal law. And naabutang diha sa Republic Act 001 na kung ikaw na akusado, wala kayo ma-incur na criminal liability if below 15 years of age ka. So, timani ha, wala kay liability if below 15 years of age ka. However, nakabutang po sa balaod na if you are over 15 years of age, na kay criminal liability. So karon, let's say here comes, let's say Mr. Zona who is 15 years old. Na ay doubt sa balaod, di ba? Kay hala, asa man ko mabilong dito sa below 15 years of age or above 15 years of age na ako kay 15 man ko. So dapat i-interpret na to ang balaod or i-resolve na to ang doubt in pabor sa akusado. So since si Mr. Zona ang akusado which is 15 years old, tanawa na to asa dito sa mga provisions ang pabor sa iya. Di ba nakabutang sa RA 001 na pag ikaw below 15 years old, wala kay criminal liability. So dito na to siya ibutang kay pabor man sa iyaha. So wala pasabot sa construction of penal laws. Kung naay doubt sa interpretation niya, dapat i-resolve na to na siya na pabor sa akusado. Nakuha?
Okay, sir.
Yes, sir.
Yes, sir.
Yes, sir.
Alright.
Okay, sir.
Okay na lang. Bantay bitaw ha.
Dili daw, sir.
Bitaw, sir.
Tapos daw, sir.
Sir, pwede ka maghatag, sir, og lain na example, ana, sir? Dili lang sa edad.
Sa edad, wala na ko'y uban manggunda. Kay katulong ako nabasa gud kay unsa kay Campanilla, wala siya, wala sa other books, wala na siya ihatag na example as to interpretation of penal laws or construction of penal laws. Kana lang.
Edad ra gyud, sir, kana ra gyud. Edad
Oo.
ra.
Basta in short, pag naibalaod tapos wa nakabalo ba unsaon pag-apply ani kay kalibog ba aning balaudan ni? Basta i-apply na to siya sa akusado kung unsa tong favorable favorable sa iyaha. Hindi
Okay,
siya
sir.
pa.
Gets na ako, sir.
Alright, sige. So you have here your limitations on power to enact the laws. So sa may mga limitations. So your laws should be general in application, meaning it should apply to all. Second, dapat din siya ex post facto law. Ano? Kaya kaning ex post facto law, these are laws which tend to punish an act or omission before the effectivity date of the law. So for example, ato ang 1017-5, which is the anti-cybercrime law, di ba, it took effect in 2012. So kung i-apply na to na siya to the person who committed the crime, committed cybercrime in 2000, then that is already considered an ex post facto law. So dapat dili siya dapat dili siya mo apply sa before sa iyang effectivity date. What else? So by other limitations on your power to enact penal laws. Dapat dili siya bill of attainder. So bill of attainder. These are laws which tend to punish you without the benefit of due process. So for example, kung isa may nadakpan kasi nag-release og bagong balaod, isa may nadakpan na nangawat og cellphone na Apple, diretso mapriso og 10 ka tuig. Wala may benefit, wala may due process, di ba? Diretso man dayon. So that is what you call bill of attainder. And lastly, you have here, it must not impose cruel and unusual punishment nor excessive fines. Again, this is by virtue of your Human Rights Convention. So, if you can, ambot ko, makita na ba ninyo karon by now? Tanang balaod kay, although different sila, but they tend to realign good. Kanang magsabot sila ba at the end of the day, ato ang laws are somewhat interrelated. Any questions so far?
Wala, sir.
Wala. Wala na lang. Right. Sige ganun. You have here your theories underlying the revised penal code. You have your classical theory, your positivist theory, and your mixed theory. When you say theories, when you create criminal laws, asa tawag hugot o basis nato. So it could be classical, it could be positivist, it could also be mixed. Now, sa man ni classical theory or the juristic theory, according to this theory, man is a rational being. So he can distinguish right from wrong. So if he commits a crime such as murder, kabalo siya na mali yun siya. Since kabalo siya na mali siya, he should prepare himself for the consequences of his action. Now, juristic view or your classical view is anchored on the philosophy, an eye for an eye, a tooth for a tooth. So when you are under the classical theory, ang purpose imong penalty is retribution, meaning dapat na revenge on the part of the victim kay katong accused na gibuhat na dautan sa mukha. So, in short, the offender is made to suffer for what he has done. So, dili talaga tanaw sa human element of the crime. Atong ginatanaw is ang iyahang offense o ang iyang binuhatan. Now, your RPC mostly is classical, based on the classical theory. Muna ka ng katong Spanish Codigo Penal, very dagko itong mga unsa dagko itong iyang mga punishment sa una. Ay mga capital punishment, anak, kay heinous crime, good. Now, you have here also your positive or realistic theory, which is the opposite of the classical theory. According to this theory, we can simply consider a crime as permanently governed or continuously governed by laws. So you also have to take into consideration the environment of the actor or the accused, his social conditioning, and to determine what is wrong in order to fix the proper penalty of his crime he committed. Okay, when you commit a crime, according to this theory, there are a lot of factors to consider. Now, the purpose of your positivist theory is reformation, meaning hatagan og chance ang akusado to reform, to change, to grow. So, under the positivist theory, I great respect for the human element because according to this theory, ang offender is socially sick. So we have to reform him. So sa may mga criminal laws or laws related to crime na form out of this positivist theory. So an example is your probation na law. Iba ang probation if you committed a felony or an offense which has a penalty of 6 years and below, laki chance na mag-apply for probation because since it's just a less grave the crime, you are given the chance to reform, you're given the chance to change your ways. So mao na ang nanganong naatay probation law. So paman, example, let's say, sa classical theory, katong pag-roll out sa capital punishment, di ba, via cilia electrica, via injection of, I forgot the component of that injection, na it will stop the beating of your heart. So, kung kada ng mga capital punishments, these are born out of the classical theory kay tungod heinous crime ang imong gibuhat, tungod imong gibuhat na karong maldumal, then you should also be meted out with the greatest penalty, which is death. So mo na difference sa classical and sa positivist theory. Classical, much more on wala siya human side, wala siya respect for the human, but whereas ang imong positivist naga-consider siya sa possible chance of the accused to reform or to change. You have your eclectic or mixed philosophy, which combines both the positivist and the classical thinking. So these are crimes that are economic and social in nature and should be dealt with in a positivist manner and making the law more compassionate. Kung sa may example, kaning unsa libel, as much as possible dili imprisonment ang patong ani, as much as possible fine lang kay yun nga, we have to be compassionate. Alay mo na kayaw-yaw lang siya ingana due to hinanakit sa iyang kauban. So your classical theory versus positivist theory. The classical theory gives more emphasis upon the act rather than the actor. whereas the positivist theory gives more emphasis on the actor rather than the act. So there is a focus of the attention on the doer rather than on what he did. Mao na ang difference sa duha.
So, answer ka ng ang positivist theory sir mula makatao siya.
Yes,
Tapos
yes.
ang classical kung unsay batas maogi kuan wa anay kuan kung judge ko tapos ang nakasala ako ang amahan. Tapos classical theory ipakulong gid ako siya wa koy kuan sa pamilya bimeon sa.
Murag martial law gani kayo. Walang classical theory. Alright, so we've already discussed this. If you study criminal law, you have to encounter these two terms, which is mala in se or malum in se and mala prohibita or malum prohibitum. When you say mala in se, it means it is inherently evil. Bad yun siya or wrongful. So, examples of your crimes, mala in se are murder, rape, and that. Now you also have what you call mala prohibita. Crimes which become wrong only because a law punishes the same or due to public view. Again, an example of your mala prohibita na mga offenses are Republic Act 9287, which is your betting of illegal numbers, PD 1602, illegal gambling, PD 449, or the cockfighting law. Kung tanawan gini mo, kung mag-away ang duha ka manok, wala mag-gimbali diha, di ba? But due to public view, due to draining resources of the people, hindi na naman mag-bet ng tao sa manok. So it's considered as mala prohibita due to public view. Nakuha ang difference sa duha?
Yes, sir.
Alright. Article 2 na ta. So may Mr. Abarca. Mr. Abarca. Agoy, absent.
Sir.
Ah? Absent ka, Mr. Abarca?
Sir.
Alright, read article
Present, sir.
Read Article 2, Mr. Abarca.
Article 2, application of each provisions except provisions, except as provided in the treaties and laws of preferential application, the provisions of this code shall be enforced not only within the Philippine archipelago, including its atmosphere, its interior waters and maritime zone, but also outside of its jurisdiction against those who, number 1, should commit an offense while on a Philippine ship or airship. Number 2, should forge or counterfeit coin or currency note of the Philippine Islands or obligation and securities issued by the government of the Philippines Islands. Number 3, should be liable for acts connected with the introduction into these islands of the obligations and securities mentioned in the preceding number. Number 4, being public officers or employees should commit an offense in the exercise of their functions, or number 5, should commit any of the crimes against national security and the law of nations defined in Title 1 of this code.
Okay, thank you. Alright, so ito may pasabot aning Article 2. It says here, application of its provisions except as provided in the treaties and laws of preferential application, the provisions of this code shall be enforced not only within the Philippine archipelago, including its atmosphere, waters, maritime zone, but also outside of its jurisdiction. Pasabot, kani sila ang mga example of exemption sa territoriality principle. Diba, as a rule, criminal laws shall only apply within the territory of the Philippines. Diba? But your Article 2 provides unsa ang mga exceptions na pwede outside the territory of the Philippines mo apply gyapon ang criminal laws. So what are your examples na of extraterritoriality, meaning Philippine criminal laws may apply outside of the Philippine territory if you commit an offense while on a Philippine ship or airship. Number 2, if mag-forge or counterfeit ka ng any coin or currency note. Third, if mag-introduce ka o kaning mga obligations and securities sa government of the Philippine Islands. Fourth, if public officer ka or public employee, nag-commit kang offense in the exercise of your function. And lastly, if mag-commit kang crime against national security and the law of nations. Isa-isa ho na to na siya. Your application of your revised penal code, which is particularly Article 2, embraces two scopes, intraterritorial or extraterritorial. Meaning, your Philippine laws will apply sa territory sa Philippines as well as extraterritorial, meaning apply siya outside the Philippine territory also, but subject to some exceptions. Now, this one of your exceptions is your Philippine ship or airship. First, wait lang. Wait lang. My allergies are going haywire for a second. Right, sorry about that. I'm having trouble with the environment. Nag-induce lang ako ang allergies, especially kanina weather. Right, sige. So what is considered a Philippine ship or airship? So a vessel is considered a Philippine ship only when it is registered in accordance with Philippine laws. So yung asa man ka magpa-register ani? So you have to register it with the Philippine Bureau of Customs. So you will know that a vessel or a ship or an airship is registered under Philippine laws if it is registered with the Philippine Bureau of Customs. Now, under international law, as long as Philippine ship is not within the territorial waters of a foreign country, the Philippine laws shall apply, shall govern. Now, for example, si Mr. Tulo o si Mr. Sumambot, disakay og airplane. Ilang gisakay kay Cebu Pacific. So, normally, it's a Philippine ship because it's registered under Philippine laws, right? Let's say na sila sa high seas. When you say high seas, kanang dagat na walay territory ang isang country. Now, since this ship, this aircraft is registered under Philippine laws, it is as if territory gyapon na sa Pilipinas. So your Cebu Pacific carrier number 16J15, whatever that, what you call that, let's say naamo sa Himpapawid. Yeah, let's say naglagot dahil si Mr. Sumambot kang Mr. Eulosias. So yan gibuhat gidunggam niya si Mr. Eulosias, dahil si Mr. Sumambot. So what Philippine law will apply? Of course, what law will apply? Of course, ang mag-apply sa ilaha is ang Philippine law. Why? Because ang aircraft is an extension of the territory of the Philippines by virtue of its registration. So it is as if you committed the crime within Philippine territory. So you will be what? Tried under Philippine law, under a Philippine trial court for the crime of murder because you committed the crime of murder while on a Philippine aircraft. So mo nang example sa mga Philippine ship or airship. So but it has to be on the high seas. Ano man? Kaya kung buadto na ta sa, let's say, nag-fly over ka sa Japan. So kung if let's say lay over na ka dito gipatay ni Mr. Sumambot si Mr. Eulosias, then ang mag-apply na law would depend kay natay ginatawag na natay ginatawag na English rule or French rule. When you say English rule, this holds the view that a crime is committed on board a foreign vessel, and while that vessel is in the territory of another country, the crime shall be tried under the law of the territory where it is committed, unless they merely affect things within the vessel or they refer to the internal management thereof. Or the French rule, or the opposite of your English rule. The French believe that if a crime is committed on board a foreign vessel while the same is anchored in another country, the crime should be tried not in that country but in the home state of the vessel or kung asa siya nakarehistro, unless their commission affects the peace and security of the territory or safety of the state is endangered. Now, so pa, crimes on Philippine ship or airship. If within the Philippine waters or atmosphere, Philippines has jurisdiction. If on the high seas, Philippines has jurisdiction. If within the territorial waters or atmosphere of a foreign country, jurisdiction is dependent on English or French rule. So, muna ko ginaingon. So, again, recap ta. Let's say, si Mr. Sumambot and si Mr. Eulosias isakay og Cebu Pacific carrier J197 bound to Japan. So let's say napa sila sa Davao, lupad pa siya, napa siya sa may Cebu na area. So di ba Cebu na area is still within Philippine territory. So let's say gidunggam ni Mr. Sumambot si Mr. Eulosias. So ang mag-apply gyapon na criminal law is ang Philippine law kay it is still within the Philippine atmosphere kay naalang man sa Cebu. So makatag na po tayo example sa second, if on the high seas. Let's say from Davao bound to Japan, naa sila sa high seas or international waters, meaning kaninang mga waters dili territory sa any country. Tapos dito gidunggab ni Mr. Sumambot, si Mr. Eulosias. So, Mr. Sumambot will be liable under Philippine law because he committed the crime while on a Philippine ship, tapos while also on the high seas or international waters. Now, what if that carrier or that plane is over Japan territory na? So, question siya ta. Unsa ang gina-practice Japan? Is it English or French rule? So when you say English, di ba? It should be tried by the what? Di ba nakabutang dire? Territory. So let's say kung English, let's say ang Japan na ang imuhang carrier or imuhang aeroplano na over Japan. Tapos gidunggab ni Mr. Sumambot si Mr. Eulosias sa while on Japan territory. So ang mag-govern if English ang gina-apply sa Japan is ang Japan law. However, if French rule ang gina-practice sa Japan, then balik ta. Kung sa mo tong flagship nationality sa imuhang airship, then dito ka sa Philippines mag-apply ang imuhang criminal law. Nakuha.
Yes, sir.
Yes, sir.
Regardless of the citizenship, sir.
Ah?
Regardless ng citizenship ng victim.
Yes, regardless of the citizenship of the victim. Kaya diba, you committed a crime while on a Philippine ship or airship.
So, kung French roll ang gipakuan sa Japan, sir, tapos dito ko gipatay, si Mike, sir, dili madakpan unless mo balik siya sa Japan ay sa Pilipinas.
Madakop gyapon siya. Madakop gyapon siya kay namatay mga marshals diya sa airport.
Example,
Unless
sir, karon sir, kanang kay kuan, kinsa na kanang gikuan gani nga Ginoo siya kanang giwanted karon sa FBI,
si
si Kibuloy.
Tuloy o
Kana si
Buloy.
Kibuloy. Giwanted man siya sa FBI, sir. Kung naa siya sa Japan, pwede ba siya dakpon sa FBI?
okay. Ingani ha. Iklaro ko sa nato kung sa iyang na-commit. Di ba lagan siya na-commit mga crimes like for example, money laundering, ato mga trafficking of persons, trafficking of napaganit sa mga let's say kani sila. But these were committed in the United States. Okay? Ayun din na siya i-attach sa Philippines. Kaya nga ano, di ba? When you say, usually di ba, ang criminal laws are territorial. So meaning, i-commit niya to dito while na siya dito sa US or while man lang, let's say, continuing crime siya, what if, ana. So, wala na kabalo kung unsaon pag-extradite aning Pastor Kibuloy if na sa Japan. Kaya wala na kabalo sa extradition laws sa Japan. He has to be extradited in short. He has to undergo extradition proceedings, meaning undergo siya proceedings of extradition before siya kuhaon diri sa Philippines. As to extradition, dili kay ko familiar because very rare lang kayo extradition diri sa tuwa.
Dili ba Interpol ang mukha na sir?
I am not familiar who will issue the warrant as against the accused because again these are foreign laws, not Philippine laws.
Oh, pero kung kuan, sir, murag applicable ra ng extradition kung iagi sa legal means. Pero kung i-backdoor nga pagdakop, tapos dili pahibalo sa gobyerno kung asa siya gidakop, kung gidakop siya sa Pilipinas, tapos di mahibalo ang gobyerno sa Pilipinas, wala ra gyapon na iko ano.
Yes, you have to undergo the proper proceedings. Right, nakuha ang Philippine ship or airship. Klaro ha?
Yes, sir.
Okay, so let's go back here. Heading 2 and 3. Should forge or counterfeit any coin or currency on the Philippine Islands and obligations and securities issued by the government of the Philippines. That also includes the introduction of your counterfeit coin or currency and obligations and securities. So, ang pasabot aning duha, let's say kumito na punti ka, Mr. Sumambot ha. Okay. Very familiar na ko sa yung apelido. Let's say si Mr. Sumambot na sa Taiwan. And then sa Taiwan, dito siya nagbuhat og counterfeit na Philippine money. So, dito siya nagbuhat siya daghan na, let's say, 1,000 pesos. Although naa siya sa Taiwan, and dapat Taiwan law ang apply or whatever, but since he forged or counterfeit the currency note of the Philippine Islands, then Philippine criminal law will apply to him. Kaya very klaro man, di ba, na extraterritoriality will apply if a person should forge or counterfeit any coin or currency note of the Philippine Islands. So maski dito niya gibuhat sa Taiwan, he will be tried and he will be liable under Philippine criminal law. That also goes with your obligations and securities. When you say obligations and securities, kaning mga treasury notes na ginahatag sa government, abot na kung familiar mo, nag-forge ninyo na dito, nag-introduce nyo dire, covered niya po na siya. What else? Kaning number 4, while being public officers, wait. Kaning number 2 and 3, nganong why do we need to punish these individuals who forge or counterfeit the coins or currency notes of the Philippine Islands? Gano man? Because it will damage your economy. You have to remember na kaning ato ang kwarta, this is being backed up by gold or notes or currencies na naa sa BSP o sa Bangko Sentral. So kung mag-introduce ka og forged na note, walay backup nila unsa na value. So if you introduce that into the economy, water in the economy. That's why very careful and very on the lookout when it comes to forging and making counterfeit money. Wala ang reason behind it. Okay? It will damage our economy. Number 4, while being public officers or employees should commit an offense in the exercise of their functions. So for example, let's say si Pao Chief Persida Acosta, ipadala siya sa Japan. Kaya, sige, padala ka sa Japan in order to help our OFW people. So, I will give you, let's say, 2 million yen in order to help our OFWs there. Himo sa, let's say, himo ni Persida Acosta kay iyang gipacket, nag-malversation of funds siya dito sa Japan. Then, although gibuhat niya in Japan, but the mere fact that she is a public officer and she committed the offense of malversation of funds in the exercise of her function as a public attorney, then she should be held accountable or liable under Philippine criminal law. Nakuha? So aside from your malversation of funds, pwede po bribery. Let's say, gibribe siya. Okay, I will bribe you, Persida Acosta. Kami na OFW na group ang ibuhang i-prefer or i-put into primary bigyan ng pansin kami. And we will give you, let's say, a house and lot in Kyoto, Japan. Sample, igala ang offer. So, na-bribe si Persida. So, while dito nahitabo ang bribery sa Japan, again, Persida Acosta will be held liable because Being a public officer, she committed an offense of bribery while in the exercise of her function as a public attorney. Nakuha?
Yes, sir.
Sure? Sure, ah? So you just have to remember that in order for public officers or employees to be held liable under Philippine law, the offense should be committed in the exercise of their function. Let's say, for example, si Presidio Acosta, nasa Japan, yeah, nakita siya Chanel na store, yeah, nakita siya gwapo na Chanel bag, iyang gikawat. Of course, the Philippine criminal law will not apply to her because ang iyang pagkawat sa Chanel bag is not related to the exercise of her function as a public attorney. Diba? So, mag-apply dito is ang Japan law. Kuha.
Unsa tong mag-apply nga law, sir?
Japan na law. Kay, di ba?
Martial law?
Ha? Hello?
Martial law?
Japan. Japan na criminal law.
Japan law.
Japan law.
Oh. Kay, kawat lang man sa store. Hindi man siya related sa iyang function as public attorney. So, mauna, hindi mo apply ang Philippine criminal law. Ang mo apply is ang territorial law sa Japan. So, you have to remember the requisites. Dapat ang offense in the exercise of their function. And number 5, should commit any of the crimes against national security and the law of nations defined in Title 1, 2 of this code. So what are your sample cases of crimes against national security? You have there your treason and espionage. So for example, in the United States, naka dito, tapos nakakuha kang vital information against the Philippines na ihatag nimo to another foreign country para ma-destabilize ang government. So that is an example of espionage. So since while gihimo nimo ni in the United States, Philippine criminal law will apply to you because you committed the crime against national security. So mag-apply sa buha ang Philippine law while gihimo nimo ni espionage in the United States. Nakuha?
Yes, sir.
Any questions so far?
Unsa tong 5, sir?
Should commit any of the crimes against national security and the law of nations. So let's say for example, si Lucius, espiya, nasa sa US. Tapos, nagamit siyang device para makakuha og vital information against the Philippines. Tapos, kaning vital information, gihatag niya to another country para ma-destabilize ato ang country. Now, is Mr. Eulocius criminally liable under Philippine law? The answer is yes. Why? Diba? You have to apply Article 2. He committed a crime against national security, which is espionage. So since he committed this crime while in the US, Article 2 is very explicit man, very clear na kung makakommit ka crime against national security, Philippine criminal law will apply to you. Nakuha?
Okay, sir. Okay, sir.
So, 3 questions so far sa Article 2. Remember ha, these are just examples of your extraterritoriality, exemption siya. Dapat ang general rule is criminal laws shall apply to its territory lang yun, within the territory of the Philippines. But Article 2 provides your exceptions wherein pwede mo apply ang Philippine criminal law outside of its territory. That's your Article 1 and 2 and your preliminaries. Na may pangutana?
Wala na, sir.
Are you sure?